Yeah, we've got James now from MidTech talking about intellectual property. MidTech, a company that as an HSN we work with a lot, and they offer a lot of advice to customers that we work with. So yeah, he's kindly offered to give us a whistle-stop tour of IP and sort of what it is and what it means. So yeah, I'll hand over to James to talk you through it. So thanks, James. Over to you.
Thank you. Share my screen. Everybody see that now properly?
Yeah.
Yes, sir.
Yeah, got that.
So, as Joe kindly said, I'm James from MidTech. Going to give you a very whistle-stop tour, as Paddy gave a whistle-stop tour of her topic earlier, about a basic introduction to intellectual property. Can be pretty technical. It is the law, so it might not be the most interesting topic to some. But again, I'll try and make it relevant, and I'll try and put some examples in there to show you how you can relate to it to what you do in your daily life at work. So we're going to look at who MidTech are very briefly, an overview of the 5 main types of intellectual property and how they might relate to what you do, and then briefly cover different ways in which you can take those forward. I think there's probably going to be some other sessions on how you take your ideas forward and commercialize them, so I'll probably skim over those in order to save time, and then how MidTech can help and the services that we offer via the HSN as part of the IP service. So this is a brief overview of MidTech. The NHS, as I'm sure you're all aware, and I think the 2 people that are on this call probably haven't heard this before, or maybe have. I know Amelia, we work closely with up at UHCW already, and MidTech actually used to have an embedded service up at UHCW, and we still do work closely with them, and there may be an embedded service of sorts happening again in the future at some point. So we do already have a lot of links with trusts in NHS organisations in the region, but essentially we are the NHS Innovation Hub for the West Midlands, and we act as the technology transfer department for the NHS in the region. And our main remit is to help NHS organisations protect their ideas and advise them on intellectual property, and help form the relationships and put the processes in place around that intellectual property and the potential commercialisation and spread of their new innovations and ideas. As you're aware, NHS organisations have a lot of employees, and a lot of them have some very good ideas that can help improve patient care and generate an income or cost benefit to their organisations. And helping with intellectual property really does and is very important in ensuring that you do and can achieve those benefits for the various reasons that we'll go into. Trust, intellectual property ownership can be a grey and murky area, and there's never really a set answer on who owns something. There's just different shades of grey, for the better phrase. Essentially, if you do something in the course of your employment, it is seen to be owned by your employer. But what is deemed to be in the course of your employment can be quite complex. Just because you do something in your work time and in work using work resources doesn't necessarily make it something that you've done in the course of your employment. If you're employed to be a hospital porter, for example, and you develop a new novel shoulder replacement system, you could quite rightly argue that that has absolutely nothing to do with your normal duties, and therefore the idea would probably belong to you personally. That may be good or it may be bad. Taking an idea forward personally can be difficult and complex if you don't have the support of your trust. So there's usually trade-offs to be made and conversations to be had with your trust about how you can take that forward. But that's one of the main things that we deal with on a day-to-day basis, kind of the complex area around who actually owns an idea. And some of those discussions can be pretty difficult. To give you an idea of the kind of things that we're talking about that a lot of trusts develop, we have medical devices. So we're currently working on a big NIHR funded grant application for a sequence scaffold device to help treat anal fistulas. Lots of mobile apps. Paddy alluded to that earlier. Everyone seems to want a mobile app at the moment, and a lot of the conversations we have, linking in with Medilink and NHS, or whether a mobile app is actually what people want or what they think they want. A lot of trusts develop their own in-house computer and software systems, and a lot of trusts develop their own patient information leaflets, patient pathways, new methods of treatment that they might not want to commercialize in the strictest sense in terms of making money, but they want to get it out there and disseminate it to as wide an audience as possible, but ensure that they get, written recognition every time it's used, or people don't bastardize it and improve its quality while it's still being attributed to the original creators. And all of this is linked in with intellectual property and how you control your intellectual property in order to be able to take these ideas forward. So you can see that a lot of the stuff people do in the NHS, whilst people might not think it has intrinsic intellectual property that needs protecting, which we can help with, pretty much everything you do will have some type of intellectual property value attached to it. So what is intellectual property? It's a way of making the intangible more intangible, is how people usually describe it. So it's a way of turning knowledge and creativity into something that can be bought or protected or sold or traded as you would with a physical piece of property. So when you buy a house, you have the deeds to your house, and then you can sell that house. You have a bit of paper to say that you are the legal owner. Intellectual property helps you take legal ownership and act as you would with physical property of your creative and intellectual output. So the ideas that you have for the things mentioned back here. Why bother? Stop people nabbing your ideas. Ensure that you get recognition for your work and help to achieve a patient benefit. If you don't look after your intellectual property as an NHS organisation and you want to partner with other organisations to help take your ideas forward, a commercial organisation or a company, for example, they're probably not going to be interested if there isn't some type of intellectual property protection in place, because other people can just run off and make the idea, and then it's obviously not commercially viable for the people that you're trying to work with. And obviously you want to achieve a patient benefit, and whether we like it or not, a lot of the innovations that the NHS comes up with has to be developed and taken on by a commercial partner and then eventually sold back into the NHS. And if you want to achieve the patient benefit through your ideas, and there's a good chance that you need to make sure the IP is protected, and there's a potential financial benefit back to the NHS and to you individually. A lot of trusts have intellectual property policies which detail what happens when an individual comes forward with an idea. A lot of them can be quite generous, so they'll split the money with you 50-50 up to the first £500,000 if you're ever lucky enough to have an idea that makes that much. And then there's kind of a sliding scale that reduces over time, because it's seen that an NHS organisation can spend money more wisely than an individual with £1 million, but that's open to debate. There are 5 main categories of intellectual property, many of which I'm sure you've heard of. The kind of golden standard that everyone thinks of when they're watching their Dragon's Den is patent. Have you got a patent? NHS doesn't file many patents. They're expensive. I think they're expensive, and you usually want to partner with a company before you get to that stage so they can take the costs on, and then they can manage the kind of whole patent family and life moving forward. Because the costs really do spiral, which we'll look at. Copyright, designs, trademarks, and know-how. Patents, as I say, are probably the main one you've heard of, and they protect how something works. They protect its function. So, you get a patent for a combustion engine in a car, or you get a patent for, certain aspects of how your TV works, and they can relate to certain, medical machinery which a trust might come up with, for example. And essentially they're a bargain with the government whereby they give you a right to exploit your idea for 20 years. and they will put laws in place to stop people running off with your idea. And what you give back to them as part of that bargain is you make the idea public. The idea is that a patent document is a public document, so other people can review it, and then that helps advance the science because other people can use your patents in research. If they have an idea that they want to incorporate your patent in, they can then come and ask you for permission to use your patent, and it's seen to advance the science, which can only be good for humanity and patient benefit, linking it back to the NHS. It can be quite complex. Patent attorneys do get paid quite a bit of money, and they tend to write in a different language. You have to be incredibly vague yet incredibly specific at the same time to try and capture everything, but be very specific about what your idea is. You've got to make it as wide as possible to stop other people being able to do anything similar to your patent, but you also need to make it clear what your idea actually is. And there's 4 main steps. Again, this is getting pretty technical, and you probably wouldn't have to worry about any of this because we could pick it up for you and discuss with a patent attorney if need be. But essentially, it has to be new, so it has to be novel. There has to be an inventive step that takes it over and above what currently is out there. There has to be a commercial application, so you've got to be able to sell it. I mean, you can do that with pretty much anything, so that's not hugely important. And it cannot be one of the excluded subject matters. So you can't patent a discovery, for example, because technically it already existed. It just hadn't been discovered before. You can't patent scientific theory because that wouldn't be seen to be good for science or a mathematical model. And you can't patent a method of doing business, which a lot of people find surprising. So you get WeBuyAnyCar.com. You can't patent the actual process or the method of doing business of having a kind of fancy website with an algorithm that tells you a price to buy your car, and then you take it to a garage and they buy. You can't actually patent that or protect that business model process. You can use different aspects of intellectual property to protect your algorithms and your website and your branding, for example, to link it all together, but can't actually patent a method of doing business, which is relevant in a trust when a trust comes up with a new process or a pathway. And whilst most trusts wouldn't want to bar other people from implementing best practice, just an example of how that might work. A method of doing treatment, you can't patent a method of doing treatment with, Heimlich maneuver. You wouldn't want someone coming asking for a tenner every time someone was choking in a restaurant and the Heimlich maneuver was needed, or Mr. Heimlich's going to come and sue them. And you can't patent in the UK computer programs or software. They're protected by copyright. And one of the most important things, it can't be in the public domain, which basically means you can't talk about it to anyone. So if you do come up with a good idea, if it belongs to the trust, you can talk to people about it within your organisation. But you wouldn't really want to talk to anybody outside of that, because as soon as it's in the public domain, which can even be you having a conversation with a friend in a cafe, that counts as public domain and you won't be able to protect the patent. There's various ways that you can make international applications. I won't go into these too much detail, but there's various timelines, and the costs really do start to add up. So, initial applications £5,000, and then it kind of snowballs from there, really, which is why it's best. It's why the NHS don't file many, and why it's best to usually get a company on board or someone else to pay as soon as possible. And it doesn't have to be a good idea. And this is one of the most famous examples of something which was patented years ago, which isn't a great idea. It's a centrifugal birthing machine, which I'm guessing was developed by a male, and essentially the poor victim woman was strapped in and then spun around incredibly fast in order to utilize centrifugal forces to pop the baby out, essentially. And there was kindly a net at the other end of the contraption to catch the baby if it did fly out, and stop it hitting the wall or some other object. That was actually patented, and it went through because it met all the other criteria. So it had a commercial application because you could sell it if someone was mad enough to build it and buy it. It was novel because no one had ever thought to do it before, and it was inventive if you're kind of sadistic in that way. But yeah, as I say, that's kind of an example. It's pretty famous. And I've linked these, a lot of what the examples are, to Apple. As Apple, as I'm sure you've heard, are incredibly hot on their intellectual property, and that was the first patent application front page for the very first iPhone many years ago. So you can see at the top, Jobs et al. Over in California, and obviously you can see how big that's got and how important intellectual property is. Copyright is incredibly important. The next intellectual property role we're going to look at, and it's one of the most simple forms of intellectual property, and also one of the most complex, just because of the ways it works by being simple, if that makes sense. And it is very relevant in the NHS. Some of the reasons I'll give in a minute. Copyright protects kind of written works, literary, dramatic, musical, artistic recordings, so songs people record. It protects the words that you write. It protects the presentations that you put together. So this presentation would be owned by Midtech, which is essentially University Hospitals Birmingham NHS Foundation Trust, because I developed it in the course of my work, and Amadou, who also works at Midtech, kindly made it look good from the arcane version that I'd been using for about 10 years prior to this. And it's used to protect software in the UK, which is also incredibly important. So if you were an NHS organisation, for example, and you developed a new care pathway, whilst you wouldn't be able to protect that care pathway, for example, if you put various materials together around the training that people would need to implement for that care pathway, you put documents together to help people use it, you know, you drew flow diagrams, that would all be protected by copyright, so people couldn't just come along and photocopy that material. But, and again, this is where it gets quite technical, it doesn't protect the idea itself, it protects the expression of the idea. So if you get a piece of paper and write an idea down, the idea itself that you've written down is not protected. The words that you've written down are the things that are protected. So someone can't come along and photocopy those words, but they could look at your idea that you've written down and go off and make it if it wasn't protected via a patent, for example. So, you know, it is quite simple in that it's free. It arises automatically. So as soon as you write something or draw something or record something, copyright automatically arises. You don't have to register it like you do with a patent. There's too much copyright material. You know, every time, as I say, everyone writes something down or records something, you know, you wouldn't be able to write off to the Intellectual Property Office and ask for that to be registered, because there's just not enough manpower in the country. So it arises automatically, and you put the little C symbol next to it to show people that you're using it as copyright that you own. But again, it doesn't protect the idea itself. But again, it can be incredibly useful. So the BSOTs example that was mentioned earlier, the Birmingham symptom specific triage example. And did you have a question there, Paddy? It didn't pop up.
It's just a quick one. I've heard this maybe urban myth about you're supposed to post potentially copyrighted stuff to yourself so you get a date.
Yeah, I mean, you can do. I mean, it certainly doesn't harm. I mean, if you email it to yourself, that does the same thing, because essentially you've got a timestamp. A lot of the material that you do create will have some type of metadata kind of attached to it, which sits behind what you've done if it's digital, and that'll give you a timestamp. But yeah, certainly, you know, emailing it to yourself can't hurt, and, you know, because then you will know when the copyright was first developed, and that's also useful for any type of IP, really. If you keep good
records. It's all about keeping a decent record, isn't it?
So it's keeping a decent record. If it's a patent that you're developing, you'd know. I mean, it's easier these days because pretty much everything we do is on computers, so there's already records built into it. But it certainly doesn't help to kind of keep tabs of all your emails and keep them safe and keep documents kind of stored separately from somewhere for protection. Yeah, so no, it's a good point. And you know, people did used to post papers to themselves, because then you had the timestamp, as you say. So yeah, it is an interesting one. The BSOT system is one that we've been working on for years, and that's been incredibly popular. And that was some algorithms for maternity triage, which was developed by Birmingham Women's and Children's Hospital and the University of Birmingham. And whilst they couldn't protect that via a patent, because as I say, it was a kind of a medical treatment, a medical pathway, and it's technically a method of doing business as well, I suppose. They did have algorithms and lots of training materials, and algorithms are seen as software in the UK, and software is protected via copyright in the UK. So there was a lot of value in all the training material that they put together, the documentation you needed to implement this maternity triage in your organisation, and the algorithms themselves were incredibly valuable. And we then licensed that copyright material onto other organisations to implement in their NHS trust and to use in certain, to use in their organisation, but under certain conditions, such as not being able to amend the materials, because if you amend the algorithms, it can become dangerous, and then it would be attributed back to the original creators, which isn't obviously a good thing. And again, there's lots of ways, there's lots of international treaties in place. So if you develop something or create a bit of copyright material in the UK, it will automatically be protected in pretty much every country around the world via various reciprocal copyright treaties. So yeah, copyright is incredibly important in the NHS, and it's probably one of the ones that we deal with most. Lots of trusts create their own in-house software now, which they want to commercialise, and their own in-house apps. And as I say, apps are protected. Apps are a form of software which is protected by copyright in the UK. So yeah, it's incredibly simple, as I say, because it arises automatically. You don't need to register it. But a lot of people get confused about what actually is protected, and they think that when we get lots of people say to us, "Well, I've got a copyright over this," and they sometimes think that's interchangeable with patent when they're kind of completely different, really. But everything you do is about building up different layers of intellectual property. So you're probably, the ideal standard is that you would have the iPhone, for example, which we'll look at in a bit, has pretty much every type of intellectual property built into it. So if you can't get a patent, you then move down and look at how you can fit together the different pieces of intellectual property to give yourself the best bundle of these tangible rights made out of your ideas, basically. Registered designs, I'll go through this quickly because I don't think I've done one in the NHS for about 10 years now. And these protect the outward appearance of something. They only protect the aesthetics of it. They don't protect the inner function. In the same way, a copyright doesn't protect kind of the idea itself. This doesn't protect the idea itself. It just protects the outward appearance. Lasts for 25 years. And these you do actually have to register for a registered design right, but there are also unregistered design rights. So even if you haven't registered it, but you've developed, a newly shaped mug, which you think is a brilliantly shaped mug and a novel shaped mug, if you haven't registered the design of the appearance of that novel new mug, then you could probably still rely on some unregistered design rights if someone came along and tried to copy you. But this is where kind of what Paddy was alluding to becomes very important, because you need to prove that you created your design prior to those people creating their design. So you'll want to have good records of exactly when your snazzy new mug was designed, so that you can prove that if you end up going to an IP court. As I say, you want to register it, but again, the NHS very rarely does that. Companies do though, and as again with Apple linking it back, you have the patent for kind of the inner workings of the iPhone. You would then have copyright. I'm kind of ruining the exercise we're going to do shortly. The copyright protects software, and then Apple are obviously incredibly hot on the aesthetics of their products. So right down to where the bezel is in relation to the outside of the screen, where everything fits together, the curvature of the older iPhones and the older iPads. So yeah, they're very hot on that. Trademarks, the last main tangible IP right before we go on to know-how. Trademarks, I'm sure you're aware, are the way we brand and distinguish goods and services. And they can be the most valuable of all the forms of intellectual property. So it's how we distinguish goods and services from one another. So you register a trademark. So, for example, the little apple is a registered trademark to Apple. The Coca-Cola branding, all incredibly valuable. So running into billions and billions of pounds just for this brand recognition. The value isn't on anything physical. It's just about how the quality that people associate with a certain brand. You have to register if you want the full protection of a registered trademark, which is always advisable. And it lasts indefinitely in blocks of 10 years. So every 10 years you have to renew it. And it's quite an easy process to register a trademark. You can do it yourself. We usually advise that if you're going to do it yourself, you discuss it with us first. And then we can show you how to do it by the IPO website, or you can use a trademark attorney, and it costs about £1,000 to £2,000, which when you think of, how valuable the Apple brand is or the Coca-Cola brand is now, it's a very cheap and effective form of intellectual property. And the way they work is there's 45 different classes of goods and services that are recognised around the world. And you would protect your new trademark, or, for example, the NHS usually comes up with a lot of service names, and a lot of the trusts we work with come up with new software, for example, and they have a snazzy new name for their software, and they want to go out and sell it, so they develop a name, and then you would look to trademark and protect that particular name, but you would have to choose which of the 45 classes or goods it would go into. So it's split down into stuff, ranging from lawnmowers and children's toys in kind of 2 different classes, and then it ranges up to methods of doing business, computer equipment, medical services, and pretty much everything you can ever imagine doing in the world is put into one of these 45 classes. So you would choose the classes that are most relevant to you, or we would on your behalf, or the trademark attorney would on your behalf, and then you would register your trademark in one of those classes. And that's how you can get names of goods and services that are the same, but they apply to different things. So you could get, a lawnmower brand having the same name as a piece of medical equipment, and that's because they're not seen to be in danger of being confused with each other if the public come across them. And the main reason that you have trademark laws is to stop people essentially kind of ripping off your brand and piggybacking on the back of your success and your brand recognition. Again, when you get people like Apple and other people, Coca-Cola with their very strong brand image, you will see them kind of rabidly go after people who have something that looks slightly like their trademark, because it is so valuable, and they don't want their brand to be kind of diminished by someone piggybacking on the back of it. I think there was a case of Sainsbury's recently where someone, and it looked brilliant, developed a supermarket called Sainsbury's, and he'd used the same colouring and he'd used the same lettering, and it, for all intents and purposes, it looked like a Sainsbury's, and it looked brilliant. But Sainsbury's weren't particularly happy about it because it was infringing upon their trademark and their branding. So poor Mr. Singh had to change and refit the whole front of his shop. Again, you can have unregistered trademarks. The protection isn't as good, but if you can show that you've been using a brand name or a service name in your trust for X amount of years, and it's built up a certain amount of goodwill and following, then and someone else comes along and tries to develop a similar name or similar branding, you will still have some protection. I mean, there are some strange cases, but this kind of backs up the class, the trademark class system. So I think you had Chelsea, who trademarked the word Chelsea, strangely. It got through to certain levels, but I think it might have been thrown out eventually. But their argument was they only wanted to trademark the name Chelsea in relation to fan merchandise, for example. So they were getting lots of people selling knockoff scarves outside the ground, and they wanted that to stop. So they only wanted to be able to use the official Chelsea Chelsea word on official Chelsea merchandise, which is slightly contentious, as it's obviously a real place as well. But you wouldn't get sued every time you said you were meeting a friend in Chelsea or watching Made in Chelsea, just if you did something to infringe upon the trademark Chelsea in that particular class, which would be scarves and merchandise and clothing. And there was also an interesting case of Specsavers applied to protect should have, and then there was a whole hoo-ha, for want of a better phrase, about people who are kind of protecting the English, trademarking the English language, and stopping people being able to use the English language. But again, it's probably a slight misunderstanding, because they were only protecting it in certain uses relating to their brand. So again, you can see how it's complicated, but you know, again, in the NHS, we do get quite a lot of trademarks being filed now, especially by the larger trusts who want to, you know, one, protect their overall brand, but also the branding and of certain products and projects that they work on. And again, there's the original Apple trademark, which is, you know, probably cost them a few dollars to put in back then, and now it's incredibly valuable. Know-how, I think I'm running out of time slightly, is this is the most intangible, if that makes sense. And this is kind of people's experience and people's knowledge that they've built up over the years, which is pretty much impossible to kind of quantify and to make some, you know, to protect outright. But it is still incredibly important. So you might have a patent, for example, for how something, for the function of a product, but it's kind of meaningless unless you also know how to implement and build that product. So you usually get a lot of people when they sell patents, they will also have a patent and know-how license, because there's the patent which covers exactly the function of the thing that you've protected, your invention. But there's also a lot of know-how as to how to implement it and how to develop it and build it, which go along with it. But again, if you're working in an NHS organisation, know-how can be incredibly valuable. You know, there's a lot of incredibly intelligent, experienced people working in the NHS, and that information and that experience and that knowledge can have a lot of value to organisations outside it. So it's just how you manage those relationships and how you manage that sharing of information. So you probably want non-disclosure agreements in place, for example, to protect any information that you share with other people. Yeah, know-how is very difficult to pin down, and it's, as I say, it's kind of this intangible. And it's kind of always in the background of every type of IP, but it's not something that can easily be quantified, but it is important just to bear in mind. But again, this is something that an IP advisor or mid-tech or a patent attorney that you're working with will be able to help you with. And a task which I haven't got a great amount of time for now, and I've kind of ruined it by explaining this, we went through anyway. How do the different kinds of intellectual property apply to this phone? I actually took that photo myself because I used a photo that I found on Google Images, which a lot of people do, which I forgot to mention earlier. So when you go on Google Images and people just copy and paste images that they then shove in their work or place in their presentations, you're essentially infringing on someone else's copyright. probably won't be a problem if you never really share it outside your organisation. But if you want to share it anywhere, then you might get an angry email from someone. I think we had one at UHB where someone had inadvertently used an image, and there's quite a lot of fancy technology now which can kind of go through websites and match exactly where people have got images from, and if it's an image owned by them, and you'll get a lot of stock image libraries chasing after people. So you usually advise not to do that. So I actually did that myself originally, then realised I'm an IP advisor and I shouldn't be stealing images off Google. So I took a photo of myself with my iPhone. But essentially, you know, I'll whiz through these. There's patents, there'll be hundreds of patents in an iPhone. Some will belong to Apple, a lot don't belong to Apple. So a lot of the phone manufacturers actually license and buy patents off each other to use in their own mobile phones, because their technology is already protected by the people's patents, so they can't so they haven't got freedom to operate. Essentially, they haven't got freedom to create that bit of technology that they need to make their phone work. So they'll go to Samsung and say, can we have permission to use your camera in our phone, for example. Copyright, all this coding and the software contained in the iPhone and its operating system is protected by copyright, and the ones and the zeros that the developers put together. The design, as I've mentioned, Apple incredibly hot on the design and the curves and where the buttons go, the camera placement and so forth. Trademarks, touched upon the Apple logo, worth 130 billion alone apparently, and that was a few years ago, so it's probably much more than that now. And know-how, the knowledge held by Apple employees. I'm sure Apple employees are under very strict confidentiality restrictions, so they can't talk about any new developments within their organization. They can't share their knowledge with other organizations just because it's so valuable. So you can see that you have the 5 main different types of intellectual property and how you want to apply them to everything that you do. And whilst the NHS again don't develop many things that you might file a patent for, or register a design for, they do lots of things where there's intrinsic copyright, and then that copyright, like BSOTS has, the Birmingham Maternity Triage System, that has a BSOTS trademark, which I believe they have protected, and the people who created it, Sarah and Nina, have an incredible depth of knowledge built up over many years working in this area, which is incredibly valuable. And that's why the training materials that they've developed and the consultancy that they offer people to help them implement BSOT is just as important as the actual triage system itself. I'll whiz over these because I think they've been talked about another day in the bootcamp. There's various ways that you can take your ideas forward and protect them. So you've got this bundle of intellectual property rights that you want to do stuff with, essentially. You might want to work on a collaboration. A lot of the stuff that we do now is funding projects. So people will apply for a funding grant through the NIHR or UK or any of the other big funding bodies, the Wellcome Trust, for example. And as part of that collaboration, you may develop, or you will definitely develop, some kind of intellectual property, one of the 5 forms of intellectual property, or probably a lot of the different forms of intellectual property that I've discussed. You'll want non-disclosure agreements in place, which are confidentiality agreements between all the parties, so that they can't share information outside of that. And also the information that you discuss is protected in case you want to file a patent, so you're not releasing it into the public domain, as discussed earlier. You may want a simple heads of terms agreement, which is just a non-binding way to focus people's thoughts on what people are going to do next. And then you'd move on to a fully blown kind of legal collaboration agreement, which details who the parties are, what they're going to contribute to the project, what's going to be created, who's going to own that in terms of IP, how they might commercialise it, and all those bits and pieces. Usually very important, and funders are getting incredibly hot on intellectual property now, and expect you to put an IP budget in any grant applications that you go for, which I think will be discussed in the funding section. But ways, once you've got IP and you want to sell it, you can license it to other organisations where you retain ownership of the IP and give permission to use it under certain conditions, and they have to give you money back in return, usually based on sales. So 10% of any money they make, they give to you. You can sell it outright. So you don't keep the IP afterwards, you just sell it to a company for a one-off fee, and then they go on their merry way and keep all the money afterwards. So you have to balance off how much the two, just do you think you're going to get more money in the long term if you have a royalty, or is it easier just to flog it as a one-off and kind of move on and just have the more money that you get from a one-off sale? And there's various other ways you might look to franchise it if you've developed a new process or a service within your organisation, which is something that I think someone at the UHNM tried to do, because they developed the process and they developed a new service in their trust to help women who have had cancer with wigs, and they made it into kind of really nice hair salon experience. And obviously, whilst you couldn't protect that by a patent, because it was essentially a method of doing business, it was essentially a hair salon. They had a trademark and they had processes and manuals which were protected by copyright and a trademark application. And because it was seen to be best in practice, other organisations wanted to implement that service in their organisation. So they essentially looked to create some type of franchise model where they'd go and offer all this information out and help people set up services within their own organisation. And then you get spin outs and social enterprises, which is where you create a completely new legal entity, which the NHS very rarely does, and in most cases I don't think they're allowed to do unless they're a foundation trust. How can Midtech help? Essentially, we are the NHS Innovation Hub for the West Midlands. We cover all NHS organisations in the West Midlands and offer assistance to pretty much any organisation to a basic level to discuss their IP needs via the AHS at WMAHSN. The main things we do are offer advice on IP, how to protect your ideas, how you might want to commercialise them, develop them, help trusts implement their intellectual property policies and processes. So if a trust hasn't got an intellectual property policy covering what happens when an idea is invented in their organisation by an employee and what potential revenue splits might be. Increased body of what we do now is working with trusts on collaboration agreements and funding agreements, both in helping them put their application in and advising on the IP sections of applications, and also the actual management of those projects in terms of IP, so the relationships with universities and companies and so forth. We offer IP awareness and training, which is what we're doing now, to individual organisations. And we have access to lots of specialist service, so patent attorneys and solicitors if people need specialist help. And as I say, assistance with funding applications. And we're a partner organisation of the NHS and work alongside Medilink a lot. And we help facilitate and have oversight of the Meridian Innovation Exchange platform. So essentially, we are the tech transfer office for the NHS in the region. And that was probably quite a rushed summary of intellectual property. As I say, it can be quite technical. A lot of people find it difficult to get their heads around, which is why we're here to help. Always happy to answer any question, whether you think it's relevant or not. And if we can't help, we can certainly point you in the right direction of someone who can. As I say, we're happy to help. By the NHS, we do offer basic IP advice to kind of commercial organisations and then point them in the right direction if they need to go elsewhere. But it's really understanding that what people in the NHS do does have a lot of value, and it's how you best protect that value to disseminate it in the best way possible and get the recognition that people in the NHS deserve, basically. And we're free, so free to the trust who use us. So, and that is MidTech and IP, a very brief overview.
That was great. Thank you, James. I think, you know, something that we often know a little bit about, but not too much. But you know, because there are some complicated issues with it as you've gone through, and it's great to hear a bit more of the detail and how it, you know, applies in so many different ways from someone that's, you know, an expert in the field, really. So thank you for that. It's yeah, it was really interesting and really great, and you know, very important part of the process, I think, you know, particularly with any sort of innovation or idea, to understand what the IP is and how it applies to you. So thank you for that. And just to mention as well, as well as these boot camps, if anyone interested, we have got the longer academy program that will run alongside these. So if you did want to access HSN support and mid-tech and work with us on a bit more of a tailored fashion and kind of get some more bespoke support for your pathway or your idea, then, you know, by all means apply for that longer program, because we can, you know, offer that support to you. So if you want any more information on that, then please do get in touch. We're happy to share that. So